What's up with this, Chris?
You can close all tabs.
Good. Okay. All right. Good afternoon, everyone, and apologies to the delay. We had technological problems here that delayed us being able to get all of the attorneys in to participate on Zoom. We just had that happen within the last 30 seconds, so we're ready to go. And without further delay, we will do so. This is case number 20-014780-AW. Cheryl A. Constantino and Edward P. McCall Jr. versus the City of Detroit, the Detroit Election Commission, Janice M. Winfrey in her official capacity as clerk of the City of Detroit and chairperson of the Detroit Election Commission, Kathy M. Garrett in her official capacity as the clerk of Wayne County and the Wayne County Board of Commissioners. This matter is here on the plaintiff's motion for show cause on a request or petition for injunctive relief. Let me have appearances for the record first, if I could, please. Starting with you, Mr. Coleman.
Yes, thank you, Your Honor. David A. Coleman, appearing on behalf of the plaintiffs. And Your Honor, I've just been informed apparently the YouTube link is not up and they're not allowed, they're being able to see it on YouTube.
Really? I just put it on a couple of minutes ago. They can't see it?
No.
Okay, we'll get somebody working on it.
It just came on, Judge. Okay, thank you. It just came on. Thank you.
Okay. What's up? Thanks. All right. Other appearances for the record, please.
Your Honor, David Fink, appearing on behalf of the Detroit defendants.
Your Honor, Lawrence Garcia, Corporation Counsel for the City of Detroit on behalf of the city defendants.
Gerald Bresek, also on behalf of the city defendants.
James Nocita, Assistant Corporation Counsel on behalf of the city.
Janet Anderson Davis on behalf of the County Clerk and Wayne County Board of Canvassers.
All right, there's a preliminary matter that we have, a couple of preliminary matters we need to take care of before we proceed any further. There has been a motion to intervene in this matter, and that is by the Michigan Democratic Party. And it is my understanding that with regards to this motion to intervene, that under MCR 2.209A2, that there has been a stipulation to their intervening. Is that correct, Mr. Coleman, or no?
That's correct, Your Honor. Thank you.
Okay, thank you.
Your Honor, sorry for interrupting. I've been getting messages that the public YouTube link is not working. And I've asked them to refresh it, but I've heard from a couple of people.
Okay, we'll get on that.
Thank you.
Because I have it on, it's indicating that it's live and that it is working. I will, obviously all I get is the icon that indicates that it's working. But we'll have our IT people work on that right away. All right. So let me hear on behalf of the Michigan Democratic Party appearances for the record, please.
Mary Ellen Gurwitz for intervening defendant, Michigan Democratic Party.
Good afternoon, Your Honor. Scott Eldridge, also on behalf of the intervening defendant, Michigan Democratic Party.
And Your Honor, John Devaney, also on behalf of the Michigan Democratic Party, and I have a Pro Hoc Vice application pending.
I know that it is pending. I've received some word that all of the steps in terms of the application are complete. I know that sometimes it runs a little bit behind. When we had our hearing last week, it turned out that it was, came like within hours of the matter being completed. Everything seems to be in order. I'll allow Mr. Devaney to participate.
Thank you, Your Honor.
Mr. Nevin, can I ask you, are you able to see anything on YouTube here or no? Are you having problems?
Yes, it's on now, and my media is watching.
Okay, great. Thank you so much. All right. All right, I think we're ready to proceed at this point. If I could, let me just preliminarily, let me start with you, Mr. Coleman. What I want to do here, if I can, is make sure that I'm aware of the injunctive relief that you are seeking. In terms of my review of your pleadings, it's my understanding that first you're looking for me to enter an order that would require the defendants to conduct an independent and nonpartisan audit to determine the accuracy and integrity of the November 3rd election, that you are seeking an injunction to prohibit the defendants from certifying the election results until the matter has been heard by this court, and that you are also then asking this court to void the November 3rd election and order a new one to be held. Is that correct, or has your relief changed, or what? I just want to make sure that we know exactly what it is you're seeking and we can proceed from there.
Sure, Judge. I would agree with the first 2 points that you made, the request for the audit based on the constitutional provision, an injunction to stop any attempt to certify the election results until that audit is complete. We also asked for a protective order, Judge, regarding evidence. And we had a pretty comprehensive list, I think, in our motion of the types of evidence that we would ask the court to issue a protective order that it not be destroyed. As to the other forms of relief, including the possibility of the court voiding the election or whatever, I am not asking for that relief today. Obviously, we have no opportunity to have had an evidentiary hearing and have the court, hear from witnesses and experts and all of that. So I would not be asking for that. So I think our relief would be limited to those 3 things, Judge. Thank you. Okay, thank you. Well, Mr. Coleman, since, as I'm sure you know, that with regards to your request here today under MCR 3.310A4, you have the burden of proof. I think we're all familiar here today with the 4-prong test with regards to the injunctive relief. And I would let you begin and address those 4 prongs, if you will, and then anything else you want to share with me, I'll hear from the other parties here. And since it is your burden and your motion, you get the rebuttal. So whenever you're ready, if you would.
Thank you, Your Honor. Apologies, Chief Judge. Would you mind allowing permission to media to record the YouTube?
Sure, that's fine.
Thank you.
Mr. Coleman, whenever you're ready, sir.
All right. Thank you, Judge. May it please the court. I know the court's had our complaint and the attached exhibits, the affidavits. We did do a supplemental affidavit from a Ms. Carone yesterday. And then we did do a reply, a very brief reply brief this afternoon, just about an hour or so ago, in response to some of the information we received today. And we have an affidavit from Ruth Johnson, our immediate past Secretary of State, that is attached to that. And I would indicate to the court, Ms. Johnson is not in her office or in Lansing today. She was at home. She has signed it. As an officer of the court, I can assure you that's her signature. And we had direct conversations with her. She is going to have it notarized tomorrow. We will supply the notarized version as soon as it's received. But obviously, we're all on pretty short timeframes here. So I just wanted the court to be aware of that being in the court file.
Before you go any further, Mr. Coleman, let me ask you, you said that you had a supplemental affidavit from a Miss Carone?
Right. We filed that yesterday afternoon about 4:15 or 4:30. And and it was served on everyone.
Okay. I may have my staff be back in touch with your office tomorrow, because as I was reviewing everything this morning and early this afternoon, I didn't see that, but it may be just sort of lost in the electronic loop here. But
okay,
I may have my staff double back with you tomorrow. Okay.
If I may, Your Honor, we have not seen it either. And I've tried to follow everything as closely as we can. We pull everything that comes up, but we have not seen that affidavit.
Okay, well, so maybe Mr. Coleman, when we're done here this afternoon, if you would just resend it to
absolutely
everyone, I think that should address the concern. All right?
Sure, absolutely, Judge. I don't know what happened there, but I know we had the email verification. I can provide that to the court if you want, but I'm sorry it did not go through.
Okay.
But in any event, Judge, I don't see any. I know, like you say, I said, you've had a chance to review this. We've laid out the factors and all that. I just like to take a few minutes and respond to the filings by the various defendants today and answer maybe a few of the questions there. And then, if the court has any other questions for me, I'd be happy to take them whenever you'd like, Judge.
Sure.
Let me just say in general, I think the defendant's responses here, and especially the affidavit of Mr. Thomas, who we all know, is basically generalities here, Judge. They don't specifically refute the observations by and the specific claims of our witnesses who signed these affidavits. For example, Mr. Thomas never spoke, to my knowledge, to Mr. Larson, and Mr. Larson indicated the same. And the other witnesses. He talks in generalities about how he sees the system working and what he thinks was going on, but that does not directly refute the affidavits that we have filed and the factual claims that have been made. And I would point out, Judge, that these affidavits are not, generalities on our part. These are very specific claims that these people saw specific acts happening that we believe support our request for relief here. Mr. Larson was very clear that he attempted to observe the process and was blocked from doing so, the counting process. He was barred from even returning to the counting room after he had raised objections regarding ballots being counted and processed with other people's names. And that's a very serious observation and claim that he makes, and it's a sworn affidavit under oath, Your Honor, regarding this election process. And when he raised it with other officials, not Mr. Thomas, who whatever reason was not there at the time or at that conversation, as he describes the harassment and other things that happened to him, he left the room for a few moments to confer with some other attorneys to try to determine, how are they going to proceed with this. And then when he tried to return to the room, he was barred. He was never allowed in again. He was a credentialed poll challenger, had the absolute right to be there under the law, and he was barred after he had made these observations. I think that's a pretty clear, critical factor in all of this, Judge. Mr. Larson stated he was prohibited from leaning in, for example. I think Mr. Thomas talks about, well, the poll challengers were allowed to lean in and observe the ballots and stuff. Mr. Larson specifically says, no, he wasn't. That is not true. So that may have been what Mr. Thomas thinks, and this is my point. He has in general the idea of what he thinks was happening and what he wanted to have happen, but the reality was it wasn't happening on that floor. And there were many people who were being denied the opportunity to see the ballots, to see the process. They were being pushed back. They were using so-called COVID regulations, whatever those are, and other things. People actually forming human shields and standing in front of people to block them from seeing what was happening at the counting tables. Those sorts of allegations, and the allegations from Ms. Jacob, who actually works for the city, I think all of those things are much more than just kind of generalities, Judge. And while I appreciate Mr. Thomas and his years of work for our state and what he states about in general what's to occur, I didn't see anything in his affidavit or the responses that refuted what we said our exhibits say and what the witnesses say in their exhibits. Mr. Larson was very clear. He saw ballots being assigned to people who did not vote. That's a serious allegation, Your Honor, of fraud.
How does he know that?
I'm sorry?
How does he know that?
Because he was there watching it and saw them entering it on the computer, as he says in his affidavit.
Okay. And what did he see? What did he see being entered on the computer?
That ballots that had one name were being assigned to people on the computer that had a different name, is I believe the way he put it in his affidavit.
Yeah, he indicated that there were names on ballots.
Not on the, I should be clearer, Judge, the ballot envelope, not the ballot itself, the ballot envelope. Mm-hmm. And that when it was to be, looked at and determined if this was in fact a proper voter and the checking of the rolls and that sort of thing, then a different name was plugged in on the computer and used. That's what he testified. That's what he says in his affidavit.
Okay.
I'm sorry.
No, go ahead. Go ahead.
Okay, sorry, Judge. And these various actions to try to keep poll challengers from doing their job, I think, are indicative of and supportive of the overall problems that we relate in our complaint and in the other exhibits. I know that you've had time, Judge. I'm not going to just repeat all of them. There's no point. Again, Mr. Thomas wasn't there with Mr. Larson. He wasn't there with Ms. Jacob or our other witnesses that we have from the various exhibits. So he's not speaking from personal knowledge of what occurred with these individuals and the claims we brought forward. Mr. Thomas never spoke to or to the people working, to our knowledge, and he doesn't claim he did, that he spoke to the people working at the table where Mr. Larson was observing or with the supervisor there. He's making a guess as to what Mr. Larson saw based on what he thinks should have been happening. So I just want to point that out, Judge. That's a big difference. It's a very lengthy affidavit, but it honestly does not refute at all what Mr. Larson says in his affidavit or some of the other affidavits that are attached as exhibits. Just another point, Mr. Thomas says that there's no election rule that requires all absent voters to be recorded by 9 p.m. on November 3rd in the QVF. And then I would just ask the court to look at the statute, MCL 168.765, parens 5. And that statute says very clearly on 9 p.m. on election day, the clerk shall post the number of absent voters. So there's a statutory requirement. So I'm not sure what Mr. Thomas is referring to with election rules. But our point here is that the absent voters had to be final at some point, and a number of them. And to our knowledge, nothing was posted. And as Mr. Thomas acknowledges in his affidavit at various times through the following day, thousands of votes and ballots, I should say, kept coming in to the TCF Center. So I guess, Your Honor, again, I rely on our briefs and what we've argued on the points, for the granting of injunctive relief. I don't think I need to reiterate anything else there. I would simply ask the court to review Ruth Johnson's affidavit here. And again, I'll get that notarized one to you, to the court and the others as soon as possible. But she says in paragraph 5 of her affidavit she says, well, I should say back up, paragraph 4. I've reviewed the plaintiff's complaint and all attached affidavits, including this affidavit by Ms. Carone, and I'm sorry, I'll get that to everybody here. I have reviewed the affidavit of Christopher Thomas. And then she says, the paragraph 5, the allegations and issues raised by plaintiff are very concerning to me, and in my opinion, require court intervention. In particular, I'm concerned about the illegal activity alleged by plaintiffs regarding voter coaching at polling places, election staff being instructed not to request photo identification or an affidavit from persons coming to vote, and Mr. Larson's allegation ballots were being assigned to random persons on the voter list. And she says, based on my review of these documents, I believe it would be proper for an independent audit to be conducted as soon as possible to ensure the accuracy and integrity of this election. And of course, Ms. Johnson served 8 years as our Secretary of State until just a couple of years ago. And she has a lot of experience, and I don't think anybody can really contest. And that's what her affidavit says, Judge. And so we're relying on this new constitutional amendment. And I know, Judge, lucky us, we're the first ones, I think, in this court to have the opportunity to take a look at this provision. But it does say very clearly under Article 2, Section 4, and I think it's 1H, that citizens, voters of the county, that they have the right to request an audit of the results of an election to make sure to determine the accuracy and integrity of the vote. And this is a new constitutional provision. It really has nothing to do with any other statutory provisions talking about audits or anything else. There is now a new constitutional right enshrined in our Constitution 2 years ago by the voters in Michigan that gives this right to an audit. So we're asking the court to order that. And as I said, enjoin the certification until that audit is complete, because then the audit becomes meaningless if it's not completed, if the certification occurs. And to give us that protective order that we're requesting. And I think I'll just end there, Judge, and I appreciate the opportunity to be able to respond to opposing counsel's arguments. Thank you, Your Honor.
Certainly. Mr. Coleman, who is it that you are contending would do this independent audit?
Well, that's a great question, Judge, and we've been talking about that. We talked with Ms. Johnson about that. And given that this is a new constitutional provision, it's frankly unclear, but there are organizations, audit organizations that could do it. I think that would be something the court could direct or the parties could agree. I don't know. I mean, I know there's a lot of different options there, but the bottom line is we're entitled to the audit. The Constitution is silent as to how that is done. But there have been audits in the past of elections. And so I think the court could fashion the process of it. We're arguing that we're entitled to have it, Judge.
Isn't there a statutory indication that falls within the responsibility of the Secretary of State?
Well, if that statutory option is there, but remember, Judge, that was there prior to the adoption of the constitutional amendment. If this court feels that that's applicable to this constitutional amendment, I mean, obviously we'll abide by this court's instructions on how best to do that. But honestly, we asked Ms. Johnson that same question, and she was kind of like, well, I think you'd have to rely on the court as to how that happens. So we would rely on your wisdom in that, Judge. Thank you.
Okay. I'll have some other questions, I think, after I hear from everyone else, but thank you. Let me hear from you, Mr. Fink.
Thank you, Your Honor. May it please the court. By now, we've seen this before, and we're seeing it in multiple places. In some ways, it's starting to feel, in this courtroom at least, a little bit like Groundhog Day. But unlike Groundhog Day, which was funny, this isn't funny at all. We're very, very concerned about what's happening here. I will say this, though. One thing we're not concerned about is any evidence that suggests that this wasn't a fair election and a fair process for counting the votes. In fact, what we've learned is These suits have given us an opportunity to really take a deep dive into the Detroit election process and looking at the allegations in the affidavits, talking to the people who were involved, and reading what they had to say, and then comparing it to the law and the actual proper procedures. What we're finding is this was a terrific process and it was handled properly. They complain that challengers, for a brief period of time, some challengers, the number in the room was limited. It isn't that there couldn't be challengers. There were dozens of challengers, Republican challengers at all times. There were challengers for both parties present at all times. And yes, because of what was referred to as, I think by counsel dismissively, as some COVID regulation, for the health and safety of the people who were present, there had to be regulations that limited social distance. Nobody can argue with that today. That makes no sense. And what happened was, unintentionally, because it was such an open process, at a certain point, there were just too many people in the room. And at that point, the decision was made to limit the number of people who could return to the room, who could be in the room. And for a period of time, there was that limitation, although eventually that was lifted and people could come back. But we hear complaints. We heard complaints about duplicate ballots, and all we learned from that was that they were done exactly properly, in the exactly proper way. One person complained that she did not have the opportunity at TCF Center to compare signatures. No, she didn't, because the signatures were compared before any of the ballots got to the TCF Center. A proper process was in place and was followed. There's a lot of talk about the supposed backdating of ballots. Well, it turns out, first of all, it wasn't the ballots, it was an entry in the computer. And it wasn't backdating, it was dating. There was some information that was not entered for many of the ballots because of the rush of time at the end, perfectly legitimate, these things happen. And every one of those ballots were in envelopes that were time-stamped. From the timestamp on that ballot, the data was inputted. Absolutely proper, the exact right thing to do. And it shows we had a clean, clear, and open process that later can be subject, if necessary, to a recount. A lot of talk about and this one has been in the media a lot, it's been in all of these lawsuits that we've been seeing, a lot of talk about voter birth dates of January 1st, 1900, as though somebody who was trying to perpetrate a fraud would use that date. Nobody is 120 years old. We know that. Everybody knows that. But the Secretary of State, and by the way, other election officials around the country, use that date for a placeholder when a birth date is not known. And in this instance, as it's explained in the affidavits and as really is unrefuted and can't be refuted, there was a computer program that, because of the way the program was set up, it was set up for voting at polling places and at the satellite offices. But for absentee voting, it wasn't necessary to have that date. For absentee voting, validation is done by comparing signatures, not by looking at a birth date. So it was an unnecessary piece of data. They didn't have that data. They weren't supposed to have that data. So they entered it as January 1st to 1900. Everything we've learned from everything we've seen, and certainly everything explained in the Chris Thomas affidavit, tells us this was an extraordinarily carefully and well-run election. Now today, what we're being told is that this is a general affidavit, that it generalizes things, that he wasn't there for everything that happened. Well, it's not general at all. The court has had the opportunity to see it. It's something like 40 paragraphs. It runs 11 pages, lots of detail. And the detail goes right to the things that are being stated in these affidavits. It explains the signature match. It explains how duplicate ballots are done. It explains why they use the January 1st, 1900 date. It explains why ballots arrived early on the morning of November 4th, where they arrived and where they came from. There was a lot of complaint that these ballots weren't locked because they're not supposed to be. That's not the process. They were in a chain of custody. They were handled properly. What we're hearing in response to what they call as a general affidavit is a general objection. Ironically, in response to that 40-paragraph allegation, we get essentially one paragraph from former Secretary of State Johnson saying she has concerns from what she's seen. Well, Mr. Thomas was there. He was directly there. And as all of us know, for more than 30 years, he was the director of elections in Michigan under Democratic and Republican secretaries of state. He is, someone recently referred to him as the gold standard for election law, and there's just no question about it. Nobody knows the rules here better. And we didn't bring him in as an expert for litigation. We brought him in as an expert to make sure this election was run properly, and it was. It was run very, very well in all respects. And the concerns have been expressed. We've looked at them, we've looked closely at them, and there isn't one there that tells us that this is anything other than a very, very well-run election. Now, this case, as the court knows probably, is the third of 4 cases that have been filed in Michigan, all bringing essentially the same allegations. This court participated, of course, and made the ruling in the Stoddard case just last week. The court is probably aware that the Court of Claims had a case that was brought against the Secretary of State, and that one, Cynthia Stevens issued her ruling rejecting the relief sought. And then this morning, of course, this case was filed a couple of days ago, the Costantino case. And then this morning, we find out yet another case has been filed. I think we all saw it in the newspaper. And then we finally did obtain the case, Trump versus Benson. Now, they're looking for another forum and they filed suit. Now, I say they, could be different people, but a new lawsuit now is filed in the Western District of Michigan. But when you read the lawsuit, I know I've said before that one lawsuit or another was the same as something that I was involved in. In 40 years of practice, I've never had this happen, a little more than 40 years, to be honest. The new lawsuit, as Exhibit 3, attached this lawsuit. That's how close the cases are. That's how identical the cases are. They're looking wherever they can to get validation for the unsupported conspiracy theories that they have. And we see the conspiracy theories, you got to knock them down one at a time, and we're trying to knock them down one at a time. But in the end, what we find is that first, we can dispute their facts if that became necessary. I don't think it is, but if that were necessary, we could take the facts on head on. Mr. Garcia provided an affidavit explaining the presence and the process involving the challengers. The former elections director, Daniel Baxter, and who's involved in this process also on a contract basis, came in and is able to explain to us in some detail that the process was proper, and of course, Chris Thomas. But in the end, what we really need to look at is the absurdity of the whole claim, and then I will run through the factors appropriately, as I know I should. If we step back from this and think about the absurdity of what's going on here, Donald Trump received 5,000 more votes, or roughly 5,000 more votes in Detroit in 2020 than he did in 2016. There was no complaint about the 2016 election, but somehow the allegation is made that in trying to steal the election, he ends up with 5,000 more votes. And statewide, he apparently, in the unofficial count, loses by over 145,000 votes. And that becomes critical. That range becomes critical when we look at the relief they're seeking and whether it really addresses their complaint. So I'm sorry if I've gone too long on this introduction, because I want to talk about the likelihood of prevailing on the merits. Obviously, that's the first factor and often the only factor that a court has to look to. And here, it's just clear. This case is not ripe for adjudication, and it's not ripe for adjudication because there is no remedy at law until the votes have been certified. The courts are not supposed to get involved in the middle of an election, in the middle of a count. We have a whole detailed statutory procedure, and that statutory procedure is set up so that people's votes count and so that the process follows in a rational way. And if in the middle of that, a wrench is thrown into the works with an order suddenly changing things one way or another, all of the deadlines are turned upside down. The delay can upset the entire intent of the election process. In this case, it can have a tremendous effect, which we'll talk about. But for now, in terms of likelihood of prevailing on the merits, their remedy is a recount. They think something's wrong with the vote, the remedy is a recount. To get to a recount, you have to have a certified election. And ironically, they're asking to stop the certification of the election. But now let me talk about the issue that was being addressed before about the audit. Plaintiffs are asking the court to read the Constitution, the audit requirement, as an open-ended opportunity for the court to order the defendants or anybody else to conduct an audit. But the court doesn't have to do that. The Constitution reads that the citizen has the right, and this is new, as the court knows, it came around in 2018 with the Proposal 3. Citizen has the right to have the results of the statewide elections audited in such a manner as prescribed by law to ensure the integrity and accuracy of the elections. Well, it has been prescribed by law. MCL 168.131 states the manner prescribed by law. It says that the Secretary of State, in order to ensure compliance with the provisions of this act, after, and that's a key phrase, after each election, the Secretary of State may audit election precincts. Of course, it goes on and there's other details of what can be done, but it can only be done by the Secretary of State. And critically, it can only be done after the election. We can't take that constitutional provision and say that when it says as prescribed by law, it didn't mean as prescribed by law. It says in such a manner as prescribed by law. And it's been prescribed by law. So I do think it's a legitimate relief. You know, if we read the complaint and the statements that are made and take them at face value, and we take their public statements at face value, they're not saying overturn the election. They're saying make sure the process is fair going forward, is handled properly going forward. The audit will give them that opportunity. Let them come forward, bring whatever information they have, and maybe there will be some changes in the future. I don't think there will be, but there could be. And if they are, they can come out of that audit. But again, in terms of likelihood of prevailing on the merits, they would have to persuade this court that this court has both the power and should exercise the power to stop this election now, despite all of the detailed legislative pronouncements and legislative explanations of how election law works and how recounts work, that they want this court to legislate a new process that they think might be more fair. And this brings us really to the second prong that you always have to look at for injunctive relief: irreparable harm. They need to prove, they have the burden of proving to this court that they, the plaintiffs, will be irreparably harmed if they don't obtain the relief they seek on a temporary basis. Well, again, let's take them at their word that they're interested in testing the votes and the vote count here. If the certification is stopped, what happens is they don't get to the point where they can seek a recount, and they don't get to the point where they can seek an audit. They don't get any relief then. They keep themselves from getting relief. But more to the point, again, in terms of irreparable harm, all they say in their complaint about irreparable harm, in their TRO, all they say appropriately is that defendants' actions violate plaintiffs' fundamental right to vote and right to equal protection of the law. Based on their allegations, perhaps that's true. But what they don't do is make the next connection, which is, and the relief they seek will protect that right. But the relief they seek doesn't protect that right. The relief they seek interferes with that right, both for them and for other people because of the timing problem. Now, I'm going to come back to that timing issue, but still on irreparable harm, they ask that the status quo be preserved. Well, there is simply no activity in which the status quo is better preserved than in elections. We have state law and federal law that guarantees that those ballots are locked up, they're sealed, that the evidence has been created and is ready to be reviewed at an appropriate time by the appropriate people. The preservation of that evidence is best done by allowing the law to stay as it is and to go forward as it is, and to not have any court step in and try to tinker with the process, which can only cause trouble. We don't know what the trouble would be, but we know it would be trouble because there's unpredictability and there's timing issues. And that's what comes to the next issue, which is the balance of harms. The harm to the defendants if an injunction is issued versus the harm to the plaintiffs if an injunction is not issued. And there, it's not close at all. If an injunction is issued and there's a delay, a couple of things happen. One, we may be unable to complete the process in which the ballots are certified and a recount can be conducted on a timely basis. That doesn't just affect the presidential election, that affects any elections in the state. We're not talking about just a few ballots. We're talking about all of the ballots in Detroit, which affect the votes in every statewide race. And they're asking that it be stopped, that it be delayed, and because of that, the recount process could be stopped. As we've said, the audit process could be delayed. But now I really need to get to the more serious problem, the elephant in the room. And by elephant, I'm not referring to any political party. The elephant in the room is there always are some delays, always are some delays, and there's always some harm from delay. But there is no election conducted in the United States which has the potential for harm from a delay that's anything like a presidential election. And here's why. I'll say the obvious, the court knows it, but I think we have to have it on the record. And that is, if the vote is delayed, if we require a new vote, if we require an audit, if we just stop the certification, if the process is delayed and the recount process is delayed, if there's going to be a recount, the ultimate deadline could be missed. December 14th. On December 14th of this year, electors will gather all around the United States, in different states and in the District of Columbia, and they will cast the votes. The presidential electors will meet and cast their votes. They can only meet if they've been appointed. So here, if the election is stopped, there's two possibilities. One, that no electors are appointed. In an election as close as this, that could mean that neither candidate gets 270 electoral votes, and literally the election for President of the United States is thrown into the House of Representatives. Or, as some political pundits have suggested rather loudly, another possibility is if the election is thrown into question and delayed, the state legislature could attempt to assert power. We would argue, some, that they don't have that power because of the state statutory scheme. But it's been argued by pundits that the state legislature might step in and choose to appoint electors inconsistent with the way that the votes were cast. Either scenario is desperately dangerous in either scenario is completely unnecessary to provide any relief to the plaintiffs. So we're in a position where our votes could be completely disenfranchised and they have to wait a few days before they can have their recount. That's the difference in the balance of the harms. It couldn't be more devastatingly different as far as the balance of the harms. And then we come to the last factor, which is harm to the public interest. I talked about this last week, and I will try not to belabor it today, but it is so important. I have to say it because it goes to the heart of what we're really looking at here. Yes, the first harm to the public interest is the possibility that a delay could interfere with the appointment of electors, which could interfere with the selection of the President of the United States. Yes, that's a heck of an impact on the public interest. But let's be realistic and say, is there any harm if that doesn't happen? And that's what this court really needs to and has understood in its previous ruling. Even if there's no delay, even if the election results are certified and the electors are chosen, any order by this court based upon the unsubstantiated conspiratorial theories that have been advanced here, any order from this court of any kind that grants an injunction sends the loudest message possible. It sends a message to the people of the city of Detroit, but it also sends a message to the people of the United States and the world that the unsubstantiated claims, the unsubstantiated allegations of voter fraud in Detroit, the statements that have been made loud and clear that somehow the city of Detroit is corrupt, they get the label of this court saying, yes, there's a problem there. And they get it based on no evidence. There's nothing to support it, but the outcome undermines the very bedrock of our democracy, the faith of the people in the democratic process. A ruling in this case of any kind, providing any kind of injunction, no matter how narrow, provides fuel for the, frankly, right-wing fire today. Maybe next year it'll be a left-wing fire, but it provides fuel for those who want to undermine our democracy by saying voting isn't fair, voting isn't honest, there's no integrity. And let me tell you, we've learned here, the closer we get to it, every affidavit we read, every document we see, every witness we talk to shows us this was a clear, clean, open and fair election. The media appropriately was all over it. They say that in their papers, that even when they couldn't be in the room, that the media was allowed in the room. Yes, they were. But by the way, while one or two challengers may have been barred, there were always dozens of Republican challengers and inspectors in the room and participating in the process. So, Your Honor, I appreciate the court's patience. I know that sometimes I've been told I talk too long, but I do very much appreciate the court's patience and indulgence. There isn't anything more important. There's literally nothing that we do. There's no reason for us to practice law that's more important than what we're dealing with today. So I hope that the court will see, as we see, that there is just no basis for this. I probably should have responded in a couple of the individuals, and I'm happy to. If the court has concerns about any of the affidavits, I'd be happy to talk about them. I can assure the court, though, that a close review of our responses and of their affidavits shows that there's just no evidence here. There's no support for what they're saying is a problem. We're not saying they're always wrong, but we are saying that they don't understand the way the election is supposed to operate. And so they saw problems that just weren't there. Now, none of this has to be addressed because it's as simple as this case is not ripe for adjudication. We hope the court will see it that way.
Okay, thank you, Mr. Fink. Mr. Garcia, anything you want to add on behalf of the city at this time?
No, thank you, Your Honor.
All right. All right, Ms. Anderson Davis, let me turn to you, and happy to hear from you whenever you're ready.
Thank you, Your Honor. Again, I'm representing the Wayne County Clerk, and the Wayne County Board of Canvassers. And having indicated those parties, I would like to address what appears to be a general misapprehension, which is global and stems even outside of this matter. There seems to be some understanding that Wayne County or the Wayne County Clerk or the Wayne County Board of Canvassers administers, operates, or controls local elections, and especially whatever events occurred at the TCF Center. That's far from the case. Michigan, and I don't think it's unique, is a decentralized election state. By that, I mean the local clerks operate and control and administer the elections and whatever occurs on election nights. That's not a function specifically in this instance of Kathy Garrett. I mentioned her name because she's one of the named parties. And in fact, this court will note that in my brief, I indicate that actually she should not be a party to this matter. She is by statute the clerk to the Board of Canvassers, but she is not a member of the Board of Canvassers. I am understanding why the board has been added as a party, in that the injunction seeks to prevent the certification, one of the functions of the Board of Canvassers. But as to the clerk herself, I think that that is not her role and she should not be a party. Both I and the City of Detroit seem to have made similar arguments in our briefs, especially regarding the likelihood of success, or the way that we see it, the unlikelihood of success. So I'm not going to repeat any of those arguments. I would like to address the issue or one of the reliefs that plaintiff Mr. Coleman indicated today that he is seeking, and that is the preservation of evidence. Such is not necessary. No court order is necessary. There are several election statutes which specifically address the issue. The first is MCL 168.810A, paren 2, close paren. After the election, upon receipt of the election materials, the clerk immediately secures those documents, ballots, whatever, in a secure location. And she's the only person, and her staff, obviously, with access. During the canvass, should there be a need to bring in any ballots or any ballot boxes, they are returned to the ballot box, that is, the ballots are, and the boxes are locked, sealed, and delivered to their legal custodians. This is 168.823, paren 3, close paren. After the canvass, the Board of Canvassers seals the statements of returns and the poll list to prevent any tampering. That's 168.824, paren 2, close paren. After a recount, the ballots are returned to the local clerk. That's 168.875. This is also addressed on the state and federal level. On August 26th of this year, the Secretary of State, in a memo to the local clerks, directed them that ballots with federal offices are to be retained and preserved for 22 months. There is a federal statute, 52 USC section 20701, which requires that election officials retain all records, papers, applications, registrations, payments of poll tax, ballots, whatever, for the period of 22 months. So we believe that that request for relief is unnecessary. The last point goes to what evidence the plaintiffs need to present in order to get an application for leave for quo warranto. In this regard, we believe that the Barrow case is controlling, and that is 290 Mich. App 530. And in that case, the court states, under MCR 2.112, paren B, close paren 1, close paren, requires that fraud and mistake be pleaded with particularity. Specifically, the standard for pleadings for quo warranto is that they should be so clear and positive in a statement of facts as to make out a clear case of right, and should be so framed as to sustain a charge of perjury if any material allegation is false. I was in the Barrow case, and in that instance, Mr. Barrow wanted to present additional evidence to the court during the quo warranto proceedings to substantiate his application, and the court rejected that. In this particular instance, at least in the complaint, there was a request for additional discovery in order to support the application. The request for additional discovery by itself belies that plaintiffs had met the standard for an application for quo warranto. That being the case, there is less likelihood of success, and county defendants request that the motion for injunction be denied. Thank you.
Thank you. All right. Mr. Devaney, are you going to go first?
Yes, thank you, Your Honor. I think I'll be the only one speaking for the Michigan Democratic Party.
Okay, whenever you're ready, sir.
Your Honor, I will do my best not to repeat what Mr. Fink and Ms. Anderson-Davis have both ably said, but I will. There are several points that I would like to make. The first one just relates to the general context in which this motion comes before you. And obviously, we are in the midst of an unprecedented pandemic, and the expertise of election officials has never been more important. And in Michigan, as in other states, Secretary of State is delegated to election officials how they should conduct elections during this pandemic. And that expertise is due significant deference, and particularly with respect to claims of lack of observation. It's important, of course, to remember that social distancing and concerns about avoiding contamination are very much at issue here. And there's no evidence in the record from the plaintiffs about those concerns and what the election officials in Wayne had to take into consideration with respect to that. The second contextual point, Your Honor, is that you're being asked to take an extraordinary leap here. We have just a small number of affidavits that are based on hearsay and conjecture, and you're asking that you take the leap of concluding from alleged incidents in those conjectural affidavits that would result in potentially 850,000 voters being disenfranchised. If the certification is delayed, that's exactly what could happen here. And it's really an extraordinary leap that's not supported by the proof that is before you. So those are the two contextual points that I'd like to make before turning to a couple of legal issues, Your Honor. The legal issue I want to pick up on is a discussion of the audit. And there is only one audit that is provided for. The Constitution provision refers to an audit as provided by law. And the only audit provided by law is the one conducted by the Secretary of State. And Mr. Fink cited this statute earlier. I think the right site is MCL 168.31A. And that particular audit, Your Honor, says it's not a recount and does not change any certified election results. So this is an audit that would take place after certification that is the only audit provided for by law. And what's happening here is the plaintiffs are asking you to create an audit that does not exist in law. They're essentially asking you to rewrite the audit, the recount, and the canvassing statutes in Michigan, which of course is an inappropriate request. Your Honor, one issue that hasn't been addressed by the parties that I do want to briefly address is the issue of standing. And that of course is a threshold jurisdictional issue. It's incumbent upon the plaintiffs to allege some sort of specific, and to prove, not just allege, but to prove some sort of specific harm that is particularized to them. And you have nothing before you that establishes that. This is nothing more than a generalized grievance that there were flaws in the election. There's no particularized harm that's claimed with respect to these particular plaintiffs. And under the cases we cite in our brief, that's just simply inefficient or insufficient to confer standing. There are some vague claims of vote dilution, that if there were unlawful votes, that the votes of the plaintiffs were somehow diluted. There is a plethora of case law, Your Honor, that we also have cited establishing that claims of vote dilution, such as are made here, are insufficient to confer standing. Because in fact, if there was a vote dilution, it applies to all citizens and all voters equally. There's also a standing issue with respect to the poll watchers. There is no standing to assert on behalf of poll watchers a right to expanded opportunities to monitor the processing and counting of ballots, because there's no individual constitutional right to serve as a poll worker. And so, Your Honor, I think it is important to recall that threshold standing question and to give it sufficient attention, because in addition to the reasons that Mr. Fink and Ms. Anderson-Davis have cited, that too is fatal to the plaintiff's claims here. And then the two other points that I would like to make, one relates to the equal protection claims that have been asserted. And there is no sufficient allegation or proof of an equal protection claim. To prove such a claim, one, of course, has to demonstrate and prove disparate treatment. And there's no evidence before Your Honor of disparate treatment. This sort of ties back to the standing point, which is that there's no particularized injury. There's no evidence that these plaintiffs have been treated any differently from other voters in Michigan. And because of that, that is fatal to a claim under the Equal Protection Clause. And then last, Your Honor, is we articulate in our brief, and I won't walk through each statutory provision, but the plaintiffs have alleged violations of particular statutes with respect to how this election was conducted. Those are all election administration statutes. And they're asking you to take the extraordinary leap from those statutes to stop the certification and potentially to disenfranchise voters in the manner that I described when I started my argument. But if you look at those statutes, Your Honor, there is no provision in them for this type of relief. In fact, one or two of the statutes provide for specific relief is if there is a violation of them. And that relief has nothing to do with stopping certification. It has something to do with, criminal penalties, some civil penalties, but there's nothing in the statute that suggests that certification can be stopped. So you're being asked again to award relief that is nowhere contemplated in statute and certainly not in the Michigan Constitution. And so, Your Honor, those are the points that I wanted to make in addition to those of my colleagues. And I appreciate your time and would be happy to answer any questions.
All right. Thank you, Mr. Devaney.
Your Honor, I apologize. I didn't mean to talk over the court. I'm sorry.
No, go ahead.
Okay. We've been advised that the Carone affidavit was filed. I'm not sure why we didn't see it. I don't think. Anyway, I haven't read it, but I have been advised that it was filed, and I did not want to make any misrepresentation to the court about that.
Okay. All right. That's fine.
Your Honor, I'm sorry. I forgot to ask one question. Is Your Honor interested in hearing any discussion of the quo warranto argument, or is it just the TRO that is being considered today?
I'm looking at just the injunctive relief at this particular moment. Thank you, Mr. Devaney.
Thank you, Your Honor.
Okay. Mr. Coleman, it's back to you. And you have the opportunity in rebuttal to tell me whatever you would like to say. I know we don't have to plow the same field here, and I'm confident you won't do that, but in response to the arguments that you've heard, please feel free to go ahead.
Yes, thank you, Your Honor. Yeah, there's quite a few things I need to point out here in response to opposing counsel's argument. First off, regarding the audit, there is a difference, Judge, between a process audit and a results audit. And we delineate that in our pleadings. And I just want to point out to the court that the statute that is being relied upon to say, well, this is the way the audit should be done or whatever, is a process audit. And when you look at the constitutional provision that's involved here, it says specifically, we have the right to a results-oriented audit, which is not what that statute covers. I meant to say that the first time around. I just want to make sure the court was aware of that distinction.
Okay.
And so I think that's an important point. And lastly there, Judge, we cite the case, I think we attached the slip opinion. It was just recently decided, the Vogt versus Secretary of State. We attached that to our pleadings. It says very clearly statutes cannot limit constitutional rights. And it was dealing with these types of issues. So I'd ask the court to review that case that we attached that I think supports our position here. Is we are not asking for a process audit. We are talking about a results audit, which is what the Constitution permits. Mr. Fink says that Mr. Thomas's affidavit has lots of details, and that Ms. Johnson's affidavit just says she has concerns. Well, Your Honor, it's more than just concerns. She says she reviewed everything, and she says very clearly in the affidavit here that what she saw requires court intervention, in her opinion, as a Former Secretary of State for 8 years in our state. And I would point out that, again, Mr. Thomas may have had a lot of detail, and here's how we do things, and this is the way things work, and all that sort of thing. But none of that refutes the specific affidavits that we have filed here, especially Mr. Larson, Ms. Jacob, or the others. He doesn't refute any of that and wasn't there. He doesn't know what Mr. Larson saw. Mr. Larson knows what he saw. And as
well, he does, though, to a significant extent, does he not? I mean, as I read Mr. Thomas's affidavit, it seemed to me that he was, in large respects, taking allegations that were contained in the affidavits in terms of, this is what I saw, with the conclusion being this must be representative of fraudulent behavior, and that Mr. Thomas was saying, yes, you may have seen what you claim you saw, but the conclusion that you draw is incorrect for X, Y, and Z reasons. And that seemed to happen in a number of respects. I guess I read Mr. Thomas's affidavit as providing a great deal of detail in terms of explaining process, but particularized with regards to certain observations that the affiants made, for which Mr. Thomas is contending their conclusion is just misplaced.
Well, Your Honor, again, he doesn't refute what Mr. Larson claims in his affidavit that he saw. And he saw different names being used. Mr. Thomas in his affidavit doesn't say that's okay. He's just saying, well, they're supposed to do it this way, and that's what I think he was seeing. Well, he doesn't know what Mr. Larson saw. Mr. Larson knows what he saw. And he says very clearly it was different names, and ballots were then inputted into the computer using different names. That's not the same thing, Judge. And if that's true, and Mr. Larson says it is under oath, then right there is a huge piece of evidence. It's not hearsay. It's not conspiracy theories, as I hear opposing counsel talk about. This is direct evidence, Judge, that he saw that happen, and that is not refuted by Mr. Thomas.
All right. Okay. Let me ask you this too.
Yeah, sorry, Judge.
Go ahead. Please finish, and then I'll circle back because I do have some questions, and I want you to be able to respond in the way you want to, and then
that's fine, Judge. I'm happy to answer as you think of the question. I'm happy to do it however you want, Judge.
No, go ahead, please.
Okay.
Please. I don't want to interrupt your rebuttal. Go ahead.
Okay, thank you, Judge. Mr. Fink says that our case is bringing the exact same allegations as these other cases, and I think you even had a case here recently. And again, they're conspiracy theories and that sort of thing. Well, I would point out to the judge, look at our complaint. I'm not aware of any other case in this state that has raised Article 2, Section 4 and the right to a results-oriented audit of the election. I'm not aware of any other case that has done that. I'm not aware of any other case that has brought quo warranto as a means for fraud in an election process. We have no involvement in those other cases, Judge. I haven't, we have our own organization. We have our own plaintiffs here who are not parties. They're not candidates. They are just voters and residents of Wayne County. And so to try to lump us in with others, just because various lawsuits may feel that the same thing has happened, that there's been fraud or other things, and are asking the court to bring, to enter relief, doesn't mean that somehow we're all in a conspiracy together to do all kinds of stuff. We have our own case, Judge, which I think on its face is clearly very different from the other cases. And so our complaint, he says our complaint apparently, I guess, was, according to Mr. Fink, added as an exhibit in some other lawsuit that was filed. I can't remember who he said it was filed by, in federal court today or yesterday or something. Well, Your Honor, all our pleadings have been out in the public domain since Sunday night. And so it's been out there. I mean, a lot of it's been posted on the internet. I mean, our complaint, the affidavits are all available to anybody for them to use however they want. So they can be dismissive of our claims and all of that, but we have, I think, very substantial and very different claims than I've seen in any other case. And so I just want the court to not be swayed by that type of rhetoric. Mr. Fink says, talking about the various factors and the likelihood of success, and that the votes must be certified. And he says the only remedy is a recount. Your Honor, what they're trying to do here is make that the only remedy. That's the whole point. We have other remedies. We have the right to this audit, and we have this right under the Constitution. And once the vote is certified, these same individuals and attorneys are going to be here before the court saying, well, too late now, the vote's certified. Your only remedy is a recount. That's the whole point, Judge. That's why we're here. We're here before the certification because we have other remedy that we want and that is available under our Constitution. And that's what we're asking the court to do. So I think it's not correct to argue, that our only remedy is a recount. We aren't even asking for that right now, Judge. Frankly, what good is a recount of votes that if they weren't properly tabulated and if votes were improperly entered, how do you undo that at this point? A recount isn't going to do much good if all you're doing is recounting the very votes that were fraudulently put into the system. What good is a recount for that? That's why we're asking for this other relief, Judge. That's the whole point. So we just disagree with them trying to box in our requests because we are not today asking for a recount, asking the court to do anything like that. We're asking for the relief that we've already set. Now, the irreparable harm issue, I think my simple reply there, Judge, is this. You can't have an audit if the results are certified. That's the point. Because again, they're going to be arguing the only remedy is recount at that point. That's why this is so critical. And we appreciate the court giving us this quick hearing on this, given the timeframes that are there. The relief we seek is spelled out in our pleadings, and we just want the court to understand that distinction, because I think that's the key one here and the critical one for the relief we're asking. As far as the balances of the harm, that you know, the defendants can't do a timely recount right now, that it could delay the Electoral College, things like that. Well, again, it does no good to recount these invalid votes if that's the case. But I would simply ask the court this: what's more important, okay? To just certify an election result, no matter whether there was fraud, whether there was anything done that was improper, just, hey, that's the process. That's what we got to do. We got timeframes. Well, if there was some fraud or whatever happened, too bad. We have our process. Is that more important than making sure we have fair elections and where fraudulent votes and improper ballots are not being counted? Which is more important? Well, I think you know where we would come down, Judge. And so I think the balance of the harm there is fairly clear our way on that. The claim about the harm to the public interest, that we have no evidence. Judge, we've attached very specific allegations in specific affidavits of what has occurred here. And again, we've got a statement from Ms. Johnson, who is clearly well-versed in this field, saying, in her opinion, this requires court intervention. And she ran our system in the whole state for 8 years, Judge. So they can have problems with our facts and may not agree with them. I get it, and I'm fine with that. But they don't get to choose the facts. They can't sit here and say, well, there's no evidence at all. Your Honor, I respectfully disagree. There's plenty of evidence in our affidavits there. Now, as far as Ms. Anderson-Davis, I appreciate what she's saying about the protective order, but I would point out pretty much the statutes she's referring to are talking about the ballots and certain limited aspects of the election information and paperwork. There's nothing in there about the computer systems, the log records, whether or not they were connected to the internet, and all other kinds of things, which are all important. So there's no guarantee that those things are protected without a protective order. As for our application for quo warranto, again, I'm just gonna be real quick on this because I know that's really not before the court today. But I would simply say that when looking at the cases cited by the county there, almost the cases that I looked at all talked about the Ingham County case, the other one she cited, talk about an election that there was an attempt to stop an election before it was held. And that's not what we're talking about here. This is not a pre-election challenge. This is, the election's been held. It's over, Judge. And now we're in this time frame where within a short period of time, our right to request this audit is going to be gone. And so that's a key point there. And so that's why we're asking for this. And we do need all the parties, Judge, because I appreciate what Ms. Anderson-Davis is saying. I do. I mean, in terms of Wayne County canvassers, I think that's clear as far as them being a party. But we also, I believe, we need the clerk, the county clerk, because if Your Honor orders an audit and orders a results-oriented audit, and that's done, that's going to entail the county clerk being involved in this and would have to be subject to whatever orders this court puts in place. So I just put that, I just want the court to understand why we did that.
Okay, I understand that, but how does your request for injunctive relief right now impact Garrett?
I'm sorry, impact?
That was certainly one of the questions I had. In terms of your request for injunctive relief, how does that impact Ms. Garrett right now? I have the same question. Why is she a party?
Yeah. Well, as I said, Judge, it depends on how the court rules here, okay? Because if you rule that an injunction is appropriate to enjoin the certification until an audit is complete, that necessitates the involvement of the Wayne County clerk. And so that's the purpose behind it, Judge. That's why we did it.
All right.
Okay.
Okay.
Briefly, Judge, just a couple more points and I'll be done. I know I hate it when lawyers say briefly, but I'll be quick here. Mr. Devaney talks about, we're in a pandemic and all that. Well, Your Honor, we just went through a bunch of, the last 6-8 months and being under executive orders that our Supreme Court finally ruled were illegal and unconstitutional. And yet they were enforced for 6-7 months in this state as if they were totally lawful. You know, we don't lose our rights under the Constitution, under statutory law, just because there's a pandemic. So to use this as an excuse to say, look, the Republican Party, the Democrat Party, both have the right to have poll challengers there to observe and see the ballots. Look at each individual ballot, write down names, challenge, do all that. Oh, but you know what? Guess what? We're in a pandemic. You got to stand, you know, 8, 10, 20 feet back to the point where you can't see anything. We're not going to let you do that.
Where's the facts about that? That they had to stand 20 feet away.
Well, there's no question they were being forced to step back from, and that's in the affidavits that we have. 20 feet, Judge. I'm not going to. Okay. You know, I mean, but there was. I'll just
the monitors that were there. I mean,
right.
Wasn't that sort of an accommodation? I mean.
Well, but they weren't allowed to observe, Judge. If you can't observe the ballots as they're being processed and see the names and look and follow on the computer and do all those things, what good is it? So you sit there and you watch people processing ballots. You don't know whether they're good or bad or whatever. I mean, it does no good. So
that's the monitors there specifically for that purpose, so that during this time of COVID that we wouldn't be right on top of each other?
Well, again, Judge, there were ways, as Mr. Larson says in his affidavit, and we have in a few of the others, they were being denied the opportunity totally to observe. And they were being not allowed to be put back in. And I don't know which council said it, but 1 or 2 people not be allowed back in. That's a lot more than 1 or 2 people, Judge. And there's, you know, you can't say that the statute, well, maybe there's a violation, but it's no big deal. We have COVID, we have all these problems. Your Honor, that doesn't justify this. These laws are there for a reason and they should be followed. And Mr. Devaney says that our affidavits are based on hearsay. I've heard this before this week. I honestly don't know what they're talking about. How is Mr. Larson's affidavit hearsay of what he personally observed? How is Ms. Jacobs' affidavit hearsay of what she personally observed and watched as it was going on? And let me just make another point, Judge, in terms of the observing. You know, you can't see the ballot on the monitor. You know, they make a big deal of this. We got this big computer monitor here where you can watch it and everything. Well, what good does that do if you can't see the ballot? It does you no good. You have to be able to see the ballot, see the name, watch it on the monitor. They were denied that. That's the whole point, Judge. So, and to claim that this is hearsay, come on, that's ridiculous. We have direct evidence in these affidavits from these individuals. And let me just say this. They're saying you have to do it in a manner prescribed by law. Well, let me say this. You know, my dad was a circuit judge for 30 years here in the Lansing area. I've grown up in my earliest memories being around the law and in courtrooms. And you know what I always heard? I heard a judicial order that requires something that is entered by a court is just as much a manner prescribed by law as a state statute or anything else. So if this court were to order an audit and issue the injunction, that is in a manner prescribed by law. It is not only just statutes. This court has its own authority to do what it believes is appropriate in any given case. I mean, essentially, Mr. Devaney seemed to be arguing for this constitutional provision to be nothing. Well, yeah, maybe it says that you're entitled to have this audit, but you really can't get it, that you're not entitled to do it, actually do it, because you have this other process audit thing, you know, in a statute somewhere. Your Honor, again, statutes cannot limit constitutional rights, and we cite the case in our brief. So finally, Your Honor, again, I'll just say, we've given the court very specific allegations by specific people of specific events that happened. Constitutional violations, statutory violations, the things that you have in front of you, the not having the ability to observe. And I'll just say that I think it's very clear. It's interesting that it's only Republican poll challengers who were being obstructed and not allowed to return. There's no evidence at all of any Democrat poll challengers being obstructed or not being allowed to return into that room. So
can I ask you this?
Yes.
Do you have any comment about Mr. Thomas's portion of his affidavit where he said that there were individuals who were being disruptive by saying, stop the vote, or stop the count, stop the count?
Well, those were people who were outside the room, outside the hall, as I understand it. I'm not aware of any of that going on inside the voting room. That was because people were getting upset because they weren't allowing the poll challengers back into the room.
Mr. Thomas,
that's my understanding.
Mr. Thomas's affidavit indicated that this was coming from inside the room.
Well, that's news to me.
They could have put them out, but they decided not to.
Well, I saw that, Judge. That's the first I've heard of that. But honestly, that has no bearing on our case. That has no bearing. I mean, Mr. Larson wasn't sitting there standing, yelling, screaming, telling people stop the count. He was trying to do his job. Miss Jacob wasn't there standing, screaming, doing anything. Mr. Sito wasn't doing that. None of our witnesses in these affidavits were doing that. Your Honor, that's part of the smoke screen here. They point to stuff like that. It's got nothing to do with this case.
Well, who was doing it?
I'm sorry?
Who was doing it?
I don't know. I mean, it wasn't our two clients, and it wasn't any of these witnesses that are in these exhibits. Your Honor, there's hundreds and hundreds of people in this counting area. I mean, people that work, the election workers there, the poll watchers, the officials, there's hundreds of people there. So I don't know, but it wasn't our clients, and it wasn't the witnesses that we have in our exhibits. I can tell you that. So
unlikely the workers and the supervisors.
Right? I would agree with that totally. Sure.
Unlikely the Democrats.
I would agree. But all again, right. So my point would be, so what? What's that got to do with our constitutional argument here and our arguments that we make in our brief and everything here, Judge? So I'm not saying it's right. I'm not trying to justify it. I don't appreciate that either. I don't think that's right. But what's that got to do with our case here? The last thing I'll say, Judge, is Mr. Devaney talked about the statutory violations and that really doesn't matter, that, you know, he kind of indicated, well, just because statutory violations happen, that's just kind of like, well, that's just the way it is. Well, okay, so there's no remedy and there's no relief. So you could do statutory violations, but hey, that's just kind of the way it goes. I don't think so, Judge. I think we've raised enough in this case that gives this court reason to have pause and to take a look at this and inquire further. Keep the status quo by enjoining the certification at this point in time, have this audit put in place, and that's what we're asking for, Judge, based on the evidence that's before you. Thank you.
All right, Mr. Coleman, let me ask you with regards to the affiants that were actually inside the TCF Center when the absentee votes were being counted. Did any of them file any formal challenges to what they observed?
I believe that some of them did, and I think some of them tried to, but they were not allowed to, as I recall in Mr. Larson's affidavit. I'd have to look at the others to be sure. We've had so many affidavits, Judge. I know whether we submitted it to the court or not, but I know there were people that attempted to, and they were just dismissed out of hand.
In Mr. Thomas's affidavit, he makes reference to the fact that in advance of Election Day and the counting at the TCF Center, that there was on October the 29th a walkthrough for challengers and inspectors, and it was to, as I recall from the affidavit, to explain how things were going to work on Election Day and thereafter. Do you know, were any of the affiants who were at the TCF Center, did they participate?
I don't know the answer to that, Judge. I could find out for you if that's an important piece of information you would like. We were focused on what occurred on the days of the counting, you know, the Election Day and the following days. That's what we focused on. But if you'd like, I can certainly inquire and I could submit that information to the court. I'd be happy to do that.
All right, that would be helpful.
All right, I will do so, Judge.
And
And I'll supply the answers to everybody, Judge, just so whatever we submit, I will supply to everybody.
Sure. And one of the affidavits I think that you submitted expressed a concern that the AV ballots weren't transported in sealed ballot boxes.
Right.
Is there a statute that you're aware of that requires that?
Well, I think we cited a statute in our complaint, but I'm not making that the basis of our claims here today.
No, okay,
yeah,
I understand. I understand. But I assume that was part of the affidavit for a reason.
Well, it was part of to just show in general the circumstances and everything that was going on. I'm not alleging that's fraud or anything like that, if that's what the court is asking, which is why I haven't really brought it up today. I mean, that's not the focal point of our complaint.
All right. Okay. All right. Thank you. I'm going to provide a written opinion and order. It is my expectation that I will have that out by noon on Friday.
Okay. And Judge, when should I submit this information to you that you requested? By what time tomorrow? I mean, I'll try to do it as soon as I can.
Yeah, by noon tomorrow would be great.
By noon? Thank you, Judge.
Your Honor, would we have an opportunity to respond to whatever he's submitting?
Well, I'm not submitting anything substantive. I'm just submitting.
It's just going to be the affidavit or a statement as to whether or not they attended that particular
pre-election
walkthrough and explanation. I mean, I think that you can. I'm sure all sides can understand my concern about something like that, where we have allegations of certain behavior that's interpreted one way by plaintiffs, in at least the affidavits submitted by plaintiff, and some other explanations that are provided, particularly by Mr. Thomas and Mr. Baxter. So that's what
I'm not going to comment on it at all, Judge. No. I'm just going to simply say, did they attend or not? That's all. I understand that you want, right?
Sure. That's
okay.
Fine.
All right. Thank you, Judge.
All right. You'll have my opinion, I expect, by noon on Friday. Okay.
Thank you very much, Your Honor. Appreciate the time today.